Okay. Did we get the first slide? Understood what it is about? Any explanation required? I mean, understood के लिए भी no, explanation के लिए भी no. Which one is it? Did everybody get what they're trying to say on the message? Paka. Everyone. Let's continue with the second one then. Got this? Read it? So can anybody tell me in brief what exactly is this thing about? Obviously, it's about the Places of Worship Act, but what exactly does the act say according to this passage? Come on, someone, anyone. जितना समझ में आया. Yes.
So it which we choose that जो एक religious character जिसका state रहेगा after the act was passed which was in 1947. Now उसके बाद जो भी
The act was passed on 15th August 1947.
no like 15th August 1947 से पहले जो भी था
हाँ.
and बाद जो भी था there are like two
हाँ.
things. So now उसके पहले जो भी था जैसे जो सारे केसेस जैसे प्रोसीडिंग्स वगैरह होना चाहिए जो बाकी थे वो एक बार देखते जाएंगे बट उसके बाद जो भी आएगा उसको नहीं देखा जाएगा और नॉट बी एंटरटेन इन रिस्पेक्ट टू दैट last line of the past was another release director of the place in 50 days. After 15th August 1947, and such an action was taken
So we start with the first thing. It talks about what is the Places of Worship Act. We accept that India is a secular country. Secular state basically means that no religion is considered as state religion and all the religions are given equal importance. So it says that because every religion has to be given equal importance, so there is something called the Places of Worship Act, which has been created so that there is some sort of security, legal security given to different places. Now, it says that we understand that a lot of religion based problems occurred in the past. A lot of religious issues happened because, in the name of religion, a lot of atrocities has happened. But that does not mean that we can use that to do things in the future. Correct. So first is just a little bit of history. The main crux of the argument starts in the second one, where it specifically says that section 4.1 clearly stipulates that the religious character of a place of worship as it existed on 15th of August 1947 shall be maintained as it existed on that day. So according to this act, on the if there is some dispute, let us say there is some particular place of worship and people claim ke iska kuch panga hai, they will check what was that place of worship on 15th of August 1947, that one specific day, and whatever was that place of worship on that particular day, 15th of August 1947, will remain as the character of that place, right? So if you claim that this used to be a church but it was actually a gurudwara, right, but they will not check आगे पीछे, they'll say 15th August 1947 को क्या था, उस दिन अगर ये चर्च था तो it will be maintained as a church, उस दिन अगर गुरुद्वारा था it will be maintained as a gurudwara, right? Whatever was the status on that particular date will be taken as the status of that church for, or status of that place forever. Now, section 4.2 specifically contemplates that all suits, appeals and legal proceedings existing on the day of the commencement of the place of worship act with respect to the conversion of the religious character of a place of worship existing on 15th August 1947, pending before any court, tribunal, or authority, shall abate. Abate means will stop, will subside, khata, right? So it will abate, and no suit, appeal, or proceeding with respect to such a matter shall lie after the commencement of act. So when the Place of Worship Act has been enacted, so before the act, whatever suits were there, whatever cases were there in front of the court, 15th August 1947 कट ऑफ डेट था, तो इसके पहले कोई भी अगर केस, एक्ट एनैक्ट होने के पहले कोई भी अगर केस है तो अब से ये केस कंसिडर नहीं किया जाएगा. Whatever was the status on 15th August 1947 will remain the status. However, the only exception in the proviso to subsection 2 is where a suit, appeal, or proceeding is instituted on the ground that conversion of the religious character of a place of worship had taken place after 15th August 1947 and such an action was pending at the commencement of the Place of Worship Act. So Place of Worship Act जिस दिन से लागू हुआ उस दिन से पहले के सारे केसेस no longer exist, but if such a case exists जहां पे it is said that the conversion of the place of worship happened after 15th August 1947 के बाद place of worship में कोई conversion हुआ है, then such cases can be considered as pending, as valid. But the conversion itself happened before, तो जो भी 15th August 1947 को status था, that status will be maintained. So at its heart, this reiterated what the Constitution always respected and accepted: the equality of all faiths. Secularism cannot be a writ lost in the sands of time by being oblivious to the exercise of religious freedom by anybody. राइट, सेक्युलरिज्म के नाम पे किसी के रिलीजियस फ्रीडम के साथ खिलवाड़ नहीं करेंगे. इक्वालिटी ऑफ ऑल रिलीजन्स को इंपॉर्टेंस देना जरूरी है. So that's what basically the Places of Worship Act says. Did you understand both section 1 and section 2 and the exception what it says? Section 4, section 4 to and the exception. Up clear छे.
अगर इसका कन्वर्जन हुआ, बट आई हैव प्रूव्ड कि उसका कन्वर्जन हुआ था,
हाँ,
बट नॉट आफ्टर 1947, so it won't be valid.
15th August 1947 से पहले अगर कोई भी कन्वर्जन हुआ है, सब कुछ भूल जाओ. उसके पहले केस भी अगर फाइल्ड है तो वो केस कंसिडर नहीं किया जाएगा. लेकिन 15th अगस्त 1947 के बाद अगर कन्वर्जन हुआ है तो वो केस प्लेसेस ऑफ वर्शिप एक्ट के एनेक्ट होने से पहले अगर फाइल हुआ हो तो भी वैलिड रहेगा. सो इट मैटर्स दैट व्हेन डिड द कन्वर्जन हैपन. दैट्स द वन थिंग व्हिच मैटर्स. क्लियर एवरीवन? पक्का? Let's take a look at the questions then. First one. What is the implication of a law or principle stated as part of the basic structure of Indian Constitution? Now, this is more of a GK question than based on the passage. You understand what is meant by basic structure of the Constitution? What is meant by, and how do we find out what is the basic structure of the Constitution? Anyone? What is meant by basic structure of Constitution? का मतलब क्या होता है? How do we find that out? हाँ? The structure, I'm talking about not basic aim of the constitution. Basic structure of the constitution का मतलब क्या है? Aim in one sense is okay, but what exactly is meant by basic structure, and how do I find out what is the basic structure of the constitution? Huh? Yes. So basic structure is what exactly the constitution is about. What is its purpose? And to find out what is the purpose of the constitution, we have to read the preamble. And there's a very famous case. Keep it in mind. Anybody, any idea? Basic structure of the constitution वाला case कौन सा था Indian law history में? The Keshavananda Bharati case, right? So there was a famous landmark judgment called the Keshavananda Bharati case, where it was decided that there can be amendment made to the constitution as long as it does not violate the basic structure. Basic structure को change करते हुए अगर कोई law बनता है तो वो law valid नहीं है. लेकिन जब तक बेसिक स्ट्रक्चर के साथ खिलवाड़ नहीं होता तब तक लॉ बनाया जा सकता है. एंड हाउ डू वी फाइंड आउट? सो द बेसिक स्ट्रक्चर इज व्हाट द प्रीएम्बल ऑफ द कॉन्स्टिट्यूशन सेज. So if any law or principle is stated as being part of the basic structure, then what can be said? And ये passage में नहीं है. This is just a general knowledge thing which you have to identify. So can I say it places a fundamental duty on the citizens to abide by it? What are the fundamental duties of the citizens, and what happens if we do not follow the fundamental duties? Where are the fundamental duties of the citizens of India written? Obviously in the constitution, but where in the constitution? Fundamental rights कहाँ पे हैं? Fundamental rights होते क्या हैं? हाँ नहीं क्या? जवाब. हाँ? Basic rights available to the citizens from the constitution are their fundamental rights. So are there fundamental duties also in the constitution? Can you name any one fundamental duty written in the constitution? Respecting the national flag. Okay. Okay, forget duties. Do you know your fundamental rights? राइट्स के बारे में तो धबाधब सबको पता होता है, लेकिन फंडामेंटल ड्यूटीज तो सर ड्यूटीज नाम की भी कोई चीज होती है. एंड आई वुडंट ब्लेम यू because even the makers of the constitution forgot to include fundamental duties in the beginning. 1950 में Constitution of India came into force and fundamental rights were given, but till mid 70s nobody realized कि rights के साथ duties भी तो होती हैं. There are two sides of the coin. So it's only after the 42nd or 44th amendment that the fundamental duties were included in the Constitution of India, and it was Article 51A which talks about the fundamental duties. And what happens if you do not follow the fundamental duties? बढ़िया question है. She asks, are all citizens bound by fundamental duties? The answer very sadly is no. If you do not follow the fundamental duties as written in the constitution, कुछ नहीं होता है. They are not enforceable by law. हाँ? हाँ. हक आपको भर भर के दिया गया है. Slight violation of a right and you can run to the courts. But if you do not follow the duties which are on your head, तो कोई कुछ नहीं कर सकता. Sadly speaking. So with that knowledge, can A be my answer? Can I place a fundamental duty on citizens to abide by it? You can place a fundamental duty, but जो already लिखा है उनको भी abide नहीं करेंगे तो कोई फर्क नहीं पड़ता है. तो इससे तो कुछ नहीं होगा. तो A तो आंसर नहीं है. Second, only the Supreme Court can make laws in relation to that principle. Nine. Third, places a restriction on the amending power of the parliament. Fourth, it is merely a judicial jargon with no practical effect. Nah. So if it's a law, it is not a jargon, it has practical effects. So A and D तो नहीं है. But does it place a restriction on the amending powers of the parliament? It does. It doesn't. How does a law, which is a part of the basic structure, play? It can be a law for anything. Not every law which is part of the basic structure restrict the amendment powers. Right? But a law which is part of the principle can only be made by the Supreme Court. No other thing can do it. So the answer in this case is the implication of a law stated as part of the basic structure is that only Supreme Court can make laws which is in relation to that basic principle. Clear on that? But now, ordinarily, who makes the laws? First of all, which are the three arms of the government? The judiciary, the executive, and the legislature. What is the fundamental duty of each of the three arms?
Legislative makes the law.
Correct.
Executive implies the
ensure that it is
Correct.
or judiciary takes care that it doesn't get so
Correct. So the creation of law is in the hands of the legislature. The implementation of laws and schemes and everything is in the hand of the executive. And if somebody violates the law, then interpretation of the law is in the hands of the judiciary. A lot of people make the mistake that judiciary कानून बनाता है. Judiciary does not make the law. Legislature makes the law. Judiciary only protects the law. Basically, it sees if there is any violation, then what is to be done, what interpretation has to be done. Okay. Now, Aurangzeb was a bigoted Mughal ruler of medieval India. Mahant Ambi is a priest in Varanasi. He found out that Aurangzeb had demolished a temple in Varanasi and constructed a mosque above it. He moves to the district court on 24th of May 2019 for demolition of the mosque on grounds of illegal construction over the Hindu shrine. Will the court allow? Oops. Ah. So, what do we say? My answer in this case. How many of us go with a D? D for Delhi says that no Place of Worship Act place a moratorium over the court to consider any such historical event as valid or invalid. Okay. Any other option?
ऐसा लोग अच्छे नहीं है
Yeah,
worship
it is a real law.
so योगी ने जो आर्गुमेंट किया वो तो गलत हो जाएगा
क्या आर्ग्यूमेंट किया?
वो राम मंदिर वाला जो केस राम मंदिर भी नहीं उसमें भी रिसेंटली एक मौत का भी गया कि वहां से शिव जी का ये निकला
The
है
Gyanvapi issue, called the Gyanvapi issue. So one thing is we should never read one passage about the law and think that is the entire law. You have to read the law in its entirety to understand. And secondly, whatever we are reading here as part of legal aptitude is only just one or two things without any details, and is not. It may not be exactly the way we think it is. It's just for us to understand how to implement and interpret certain laws. The actual law will have 10 sentence law के होंगे तो 10,000 exceptions भी होंगे उसमें. And obviously, if somebody has, if it was illegal, do you think the case would have even been taken up by the courts? Or they could have just dismissed it right at the time it was admitted? So we'll not comment on that, but this one, क्यों क्यों valid नहीं है?
हमें पूरा हमको इस पे जज कर रहा है ना हमें जितना इन्फॉर्मेशन
हाँ, तो जितना इन्फॉर्मेशन दिया उसी के बेसिस पे आपको आंसर भी करना है. So nobody is checking your knowledge of law. They are checking your ability to interpret what is given to you as a principle. Which one?
B.
That has to be pretty straightforward, right? Because Aurangzeb obviously before 1947, and anything before 1947, if the conversion has happened, तो कुछ नहीं हो सकता. So in this case, my answer has to be D. Straightforward. Chalo. Next.
The Worship Act was in place 16 August 1947.
Place of Worship Act का year कुछ mention नहीं है.
With that,
The date it has meant 15th August 1947. Remember any? Do you know the significance of that date? 15th August 1947. What was the significance of that date? Literally celebrated it 5 days back, 4 days back. 15th August. So that date should be one of the easiest dates to remember. Bola. D for Delhi.
1992.
Babur was a Mughal ruler of medieval India. Mahant Suresh Das is a priest at the Hanuman Gadi temple of Ayodhya. He filed a suit for demolition of Babri Masjid in the district court in 1884 as it was constructed over a famous Hindu temple. The mosque was demolished by a mob in 92 even before the court could decide. The Supreme Court has decided to hear the matter in July 2020. Can the court hear the petitions? Decide.
Petition किसके बेस पे ये करना है 1992 में जो डिमोलिश किया उसके बेस पे
पेटिशन क्या होता है?
फाइल मैटर
केस. सुप्रीम कोर्ट किसको हियर करेगी? जो लीगल केस फाइल्ड है उसको हियर करेगी. सो 1992 में जो हुआ
सॉरी
उस पे कोई भी केस, वो कोई केस है नहीं, उस वो एक सेपरेट इंसिडेंट होगा, बट द पेटिशन व्हिच इट हैज टू, देयर इज ओनली वन केस व्हिच हैज बीन फाइल्ड in this entire thing. Only one case has been filed. The case we are talking about is the 1884 case, and 1884 case agar file hua hai तो can it be considered valid case now? Again the reason same, 15th August 1947.
after 1947 it was demolished in 1950 so will the court still hear it because
So what is the exception given in section 4.2?
that
If the nature of the place of worship was changed after 15th August 1947, then the case can be valid. And plus, the Places of Worship Act के enact होने से पहले अगर केस फाइल किया है लेकिन 1947 के बाद चेंज हुआ है तो कोई प्रॉब्लम है ना. Assuming that the Places of Worship Act was created before 1992, तब तो कोई फर्क ही नहीं पड़ता. After the creation of the Places of Worship in 1992, any new case which comes up can be valid. The thing that the case will be valid or not is only for those cases which were filed before the creation of the act. So in this case 1884 ka act hai, and there is absolutely nothing which can be done. So in this case the answer has to be D. Pakka. Next. Which one? B for Bombay, D for Delhi. Samudragupta was a ruler of ancient India. During his reign, Brahmanism rose to prominence. Buddhist shrines were demolished or converted into Hindu temples across the Gupta Empire. Monk Dalai Lama moved a petition for restoration of Buddhist shrines in Bihar region in 1965. Can his petition be allowed? The Supreme Court has decided to hear the matter in July 2020. So can the court hear the petitions?
worship worship है तो
कौन से साल में प्लेस ऑफ वर्शिप एक्ट आया था? We don't know. Not given in the passage.
कैसे पता नहीं
How does it matter कि प्लेस ऑफ वर्शिप एक्ट कब आया था?
एक्सेप्शन में तो हो सकता है
एक्सेप्शन क्या है?
15 अगस्त के बाद हुआ है
क्या हुआ है?
कन्वर्जन
Change in the nature of the place of worship should have happened after 15th August, right?
यस
Okay.
और वो जो एक्ट है उसके पहले पेटिशन फाइल किया होंगे
But the act of conversion of the place of worship itself should have happened after 15th August 1947.
हाँ
So how does it affect this case? 15 अगस्त 1947 के बाद अगर जगह के साथ कोई परिवर्तन हुआ है तो केस होगा. When did the conversion of the place of worship take place in this case?
No.
Right? Samudragupta, ruler of ancient India, and Samudragupta was definitely there before 15th August 1947. It is not even medieval India, it's in fact ancient India. So does it matter? Does not matter when the case was filed. The conversion, if it took place before 15th August, then what?
Before हुआ तो नहीं लगेगा.
कुछ नहीं होगा. So in this case, again, सेम आंसर जो पहले से आ रहा है, कुछ नहीं हो सकता है. सेकंड, द प्लेसेस ऑफ वर्शिप एक्ट ब्ला ब्ला ब्ला, प्लेसेस ऑफ मोरेटोरियम ब्ला ब्ला ब्ला, नथिंग कैन बी डन ब्ला ब्ला ब्ला. पक्का? चलो. Answer in this case. So Mr. Narendra Modi, all names are fictional and purely a figment of somebody's imagination. Any resemblance to any real life character is purely coincidental. There's no way they can do this and expect to win the next election. Mr. Narendra Modi, no relation to any real life person. Won his second national election in 2019. Purely fictional incident, no relation to anything which may have happened in 2019. The RSS, again, no relation to any real life organization. Had supported his campaign wholeheartedly. The RSS now pressurized the government to pass a new citizenship law which declares Indians as Hindus. The government, under pressure, drafts a legislation towards the same and puts it up for discussion on its website. And the draft is challenged before the Supreme Court. Is the draft constitutionally valid?
No.
Kyun?
Basic structures. Like this economic is particular design that all failures are Hindu, failure offending the particular part of the community. Can't create a ball with the they have the right to follow that.
Basically, is it a fundamental right given to everybody by the Constitution of India that you are free to follow your religion? And can any amendment be made which affects the basic structure of the Constitution? No. So my answer clearly in this case has to be A. It cannot be. Right? Why? Because secularism basic part of the Constitution. Yes. With me on this, everybody. Easy. Sure. Controversial but easy.
Okay.
The government of India is constructing a new airport in Noida, Delhi, and during land acquisition, the government found multiple religious shrines. The government decided to relocate all the shrines on a new land for furtherance of development work. Mant Ambi, a priest from one such shrine, approached the court on July 2019 challenging the government action. He's arguing that as per the Place of Worship Act post 1947, there cannot be any change in the character of religious places. Is the action of the government illegal? Decide. Anybody for A, B, C, D? None of the above. Your confusion life man. Okay. A says yes, the Place of Worship Act places a moratorium on conversion of religious shrines. Why?
Like the incident of
Uh,
मर्डर इंडिया तो वो तो 19 हमें क्या पता 1947 के पहले कोई भी
So then which other option will we go with? B says, is the action illegal? No, the dispute is not of historical nature and beyond the purview. But it doesn't have to be of historical nature.
चेंज द कैरेक्टर मतलब उसके वैल्यू नहीं आनी चाहिए बट प्लेसेस तो चेंज हो सकती है
The nature of that place.
हाँ
So you are changing the religious shrine into a commercial airport.
नो बट वी आर रिलोकेटिंग इट समवेयर एल्स ना
But जो original है उसको तो change कर ही रहे हो ना. By literally relocating it, that place has been changed into something else. C says yes, the government is changing the nature of land from religious to commercial.
sorry
Or D, no, the shrines are being relocated and the places of worship act does not bar that. Which one? My best option in this case should be C, right? Because if there is a moratorium on the conversion of religious shrines, there is not a moratorium on the conversion of religions. There is a moratorium on cases doing it. So basically, you cannot do it. My best option in this case definitely has to be C. Paka. Sure. Next, hopefully less controversial. Not at all. This is basically I think it was decriminalization of homosexuality, but I'm not very sure. But you can check that. Read this, mostly historical, but still any explanation? Hmm? Huh? Huh? It is a decriminalization, right? 377, if I'm not mistaken. 377. दिया हुआ है. Read? Understood? Any explanation? So passage entirely is about acceptance of things which is not heterosexual. So LGBTIQ community, it does not matter whether it is big or small. What matters is that every person should have basic rights to be included in to be counted as citizens. So 2013 Kaushal verdict was against the LGBTQ community, to which the Navtej Johar verdict, it decriminalized section 377. Any idea what was Section 377? 377 is still there, but they decriminalized homosexuality under it. Huh.
Was criminalized. So anyone who was like found to be part of the exit committee was put behind bars.
No, but what exactly was Article 377? It was not homosexuality per se. What exact? Because 377 has not been overturned. Homosexuality has been decriminalized under it. So what exactly is 377 then? So Article 377 of the, I mean, basically it says it is against unnatural acts of sex, right? So it 377 criminalizes any unnatural act of sex, to which it was interpreted that even homosexuality falls under that definition because homosexuality was considered as an unnatural act. So then a lot of cases were fought, and ultimately the this Johar case, it said that homosexuality does not fall under the definition of unnatural sex, and that's why it was considered one of the greatest landmark judgments in modern times. But 377 is basically so the ruling of the case is decriminalization of homosexuality. Confusion है पक्का okay. Cornucopia. Cornucopia, according to mythology, was a magical horn which used to give you. Have you heard? Do you know what is Akshay Patra? Cornucopia was a magical horn from which you would get unlimited amount of food, edible things. In Indian mythology, we call it Akshay Patra. Akshay Patra was the magical vessel from which you could get unlimited amount of food and beverages. अक्षय पात्र बोलते हैं उसको हाँ so cornucopia now it literally means a vast collection of things hmm? Collection of things. Mixture implies that everything is mixed. Now, this is just a collection of things. But this again basically a lot of gyan hai, but nothing of importance. The important one was the second slide. And in fact, there's not much of legal analysis done in any of the thing. It's just giving you some information that 377 के अंदर जो homosexuality was a crime has been removed by the Johar case. पक्का? चलो, let's see what the questions are like.
So it was an app.
There's the name of the person who got the case. Oops, ये क्या है? Social media नहीं. Look. Due to IPC section 377, the LGBTQ plus community was being deprived of what status, which the Supreme Court judgment corrected? Constitutional status of human dignity, equality, and privacy. And nothing of recognition of social media, recognition of marriage, and none of that. This has to be A. Chalo. So the Supreme, again, this is nothing based on the passage, it's vocabulary type question. The Supreme Court rejected the doctrine of desuetude while declaring Section 377 of IPC as constitutionally invalid. What does the doctrine mean? So, what does destitute mean? Destitute is, again, the passage will not help you. Huh? Basically, the arguments made from the other side was that ऐसे भी कोई section को use नहीं करता है, तो इसके साथ छेड़छाड़ क्यों करना है? To which the Supreme Court said, just because something is not used, we cannot let it exist, even if it is, I mean, if it is invalid, it has to be cancelled, even if it is not used. So the doctrine of destitute simply means A, the law should be upheld merely because no one uses it anyway, thus it causes no harm. So the answer here is A. So destitute, it means that nobody is using it. And just because something is not used, does it mean we should not do anything with it? No, at least not in law. The Supreme Court held that even if the number of beneficiary of its decision to declare Section 377 are insignificant, the court must declare a wrong law as wrong. The Indian Constitution rejects this principle too. What is this principle of law? Right. First of all, it's not judicial review or rights of majority. But if something is wrong, it is wrong. That statement itself tells you what it is, right? We are talking about moral values. That is called constitutional morality. This one is not relevant to the passage. Most of it then can be directly answered without the passage. Great. Okay. The author congratulates the Supreme Court judgment for being pioneering and its effect on constitutionalism. What impact is the judgment going to have on constitutionalism as per the author? Why? Why transformative?
Because of the rich tribute for its transformative constitution.
Okay, there it is given. It deserves a rich tribute for its transformative constitutionalism. So, literally, is there in the passage. My answer in this case. So, the answer we are looking for is transformative. C. Okay. As per the author, Section 377 was a symbol of what effect of criminal law on constitutional rights, which were corrected by the Supreme Court. Again, how? कहाँ पे? Let's see that then. Fourth and fifth line. It says that laws such as Section 377 represent a serious overreach of criminal law. So again, as per the Section 377 is what? This is a overreach of criminal law. What does overreach of criminal law mean? Overreach का मतलब क्या होता है? जितना आपकी औकात है उससे ज्यादा आप करते हो, आपकी लिमिट हद को पार करके कुछ करना. So the criminal law is trying to do something which it does not have the right to do. The Indian Constitution recognizes fundamental rights of its people without the state declaring the same through legislation. The Supreme Court extended this innate principle to the LGBTQ plus community of India. The state, that is India, did not make a law for this. But the Indian Constitution, the Supreme Court said the Constitution gives you this right. How is it a protection of fundamental rights? See, what does the question say? There is no law created for this, but still The Indian constitution says that you have this right. So how can I get a right if the legislature has not made it as a law? Because the constitution gives it. I don't need the legislature to make a law. So what does that mean? It means that the fundamental rights are supreme. Fundamental rights don't have to be created using laws. If it is a fundamental right, basically it is given to you directly. So it's not protecting anything. It is declaring that because it is a fundamental right, it is supreme. I don't need the legislature to create a law to make it valid for the people. Correct? Sure. Next one. Read, understood. Any questions further in the passage? Anji, got this one? Any questions? Any doubts? Any explanation required? Understood? Chalo. Nothing to do with the passage. The author premises his argument for religious classification of citizenship on basis of minority rights granted to them under the Constitution. Which part of the Constitution is the author referring to when he talks about minority rights? So, rights are there under which part of the Constitution? one, two. I think it is two. Rights are in which part of the Constitution? Parts of the Constitution. Which parts of the Constitution contain your fundamental rights? It's Article 12 to 35, but which part it is? It's part 3. Okay. Which part of the Constitution deals with citizenship? हाँ बिल्कुल है. तो ये भी तो पता होना चाहिए. Which part of the Constitution deals with citizenship? Huh? Part 1, Part 2, Part 8 or Schedule 4? Think logically. Huh? 8. A, Part 1. सबसे पहले what do you think is there in the Constitution of India? What is Part 1 of the Constitution of India? Preamble तो उसके पहले आ जाता है. Huh? The entire Constitution में बता दो human rights कहाँ पे है. If you were writing the Constitution of India, let us forget India, you are writing the Constitution of a country. What would you put in the first part of that Constitution? वो तो पूरा के पूरा Constitution वही है. पूरा Constitution वही है कि उसको कैसे चलाना है. The first thing which I would put in my Constitution and which is there in the Constitution of India is कोई तो कुछ तो बोल रहा था. The first thing I would put in the constitution of our country or any country is what is the name of the country and what is the area of this country. What is defined as India? The literal first thing I would say is my Constitution of India बना तो India क्या है? My first thing would be the definition of India. And then what would I put? Because the entire constitution is how to run the country, and by running the country I mean the people. So once I've defined what my country is, the second thing I would require to do is define who are the people of this country, and the definition of who is a person of this country is known as the citizenship. So logically speaking, the part of the Indian constitution which should cover citizenship should be part 2 of the constitution. And then part 3, once you have defined who are the people of the country, what are the rights of the people of the country? So rights comes under part 3. Thoda logically we can remember it. Correct? Chalo. Now, under what principle of constitutionalism does the court not interfere in the affairs of the legislature or the executive? पूरे का पूरा पैसेज यूजलेस है. These are all like GK questions and things you have read in civics. स्कूल में civics में पढ़ाया है आई होप.
पेपर में अगर ऐसे आया जिसके अंदर हम टाइम वेस्ट करेंगे पूरा रीड करके.
हाँ.
तो देन उससे ऐसा नहीं और फिर हम ऑप्शंस देके उसके बाद.
What do I tell about verbal reasoning? What do I tell about reading comprehension? What is my strategy which I always keep telling? I always tell look at the questions first. Even when I talk about reading comprehension passages, when I talk about verbal reasoning, मैं हमेशा कहता हूँ पहले क्वेश्चन को पढ़ो, राइट? उसके बाद पैसेज को जब पढ़ोगे ये समझ में आ जाएगा कि पैसेज में क्या ढूंढना है. एंड इफ यू आर लकी इनफ टू फेस सच क्वेश्चंस वेयर you can answer the question even without reading the passage. If out of 5 questions I'm able to answer 3 questions without reading the passage, do you think I'm going to waste time reading the passage for the remaining 2? I may or may not, depending on whether I have time at the end of the paper. पेपर के बीच में तो पैसेज को नहीं ही पढ़ूंगा. टाइम बचेगा तो 3 क्वेश्चन आंसर कर दूंगा. time bachega to I'll come back at the end to this section, to this thing. Now, right now in class, because we are constrained by technology, I cannot give you the entire material, so we are forced to read the passage and then the questions. But in the paper, when you are practicing, always read the question first. In fact, GK में तो कितनी बार होता है, most of the questions you can answer without reading the passage. Don't read the passage, take a look at the questions first. So in this case, the court does not interfere in the affair of the legislative or the executive. What is that known as? It's called separation of powers, right? The three have very distinct responsibilities and one cannot interfere with the other. So this thing, this principle is known as the separation of powers. Okay. As per the author, the CAA is being primarily criticized on what grounds? As per the author, the CAA is being primarily criticized on what grounds? A, the law amends the citizenship criterion. B, it is not changing on what basis you can become a citizen. Second, the law could have created a wider class for grant of citizenship. In fact, that's what the author says. कि जिस तरह से लोग criticize कर रहे हैं, the people who are criticizing it are saying that you should have created a broader class. To which he responds, अगर आपको लगता है कि the law should have created a broader class, you might as well remove the borders. So the third thing that he's saying is actually using it as a sarcastic way to oppose the criticism. But his main criticism, what he says the law is being criticized, is that the people criticizing it think there must be a wider class for citizenship, whereas it does not make sense. He says it makes sense the way it is because that's what is done across countries in the world. Yes, ये समझ में आया? Sometimes we do come across passages or questions which are not very argumentative in nature. Like usually we get जहाँ पे मजा आता है, कहानी टाइप होती है, but कभी कभी ये भी करना पड़ता है. चलो. Under what powers granted under the Constitution can the Supreme Court test the validity of the new citizenship law? The law is made by the legislature, but can the Supreme Court test whether it is valid or not? If yes, under what power, under what authority? It's called judicial review, the power of judicial review, right? Not every law which is created by the legislature is automatically legal, so to say, right? So the Supreme Court, it has the power to check whether the law which has been made, it follows the rules and it is legal according to the existing norms. Which class of human beings can be denied entry as per Indian citizenship laws? Which one? Anybody for A, B, C, yeah, D, both A and B. Okay, illegal migrants though clearly can be refused, but can tourists be refused entry or can refugees be refused entry? Why not?
Refugees can be legal if they are illegal, they'll count the illegal migrants.
So
Yes, they cannot be
they cannot be
denied.
they cannot be denied entry.
They can be, but the best option is illegal migrants.
Illegal migrants तो है, but why can't refugees be denied? You mean to say if I claim I'm a refugee, I have to be given entry?
If I'm talking कि इसको सबसे पहले entry deny होगी तो वो illegal migrants होगा.
हाँ, illegal migrants तो है, but what about refugees? Can refugees be denied entry as per citizenship laws? See, tourists cannot be denied entry because it's not a matter of citizenship. So C तो answer नहीं है. Now the question is, as per citizenship laws, can I deny entry to a refugee? So both A and B in this case, right? Illegal migrants, so theek hai, but even refugees can be denied entry. Just because a person is a refugee doesn't necessarily mean that they have to be denied, they have to be given entry. Okay. What does this say? What did you understand from this particular thing? It's talking about section 144 CRPC. What exactly did the Supreme Court say in the case? What does this say? See, that is a section 144 CRPC. Now, according to this section, the government is allowed to ban certain public utilities, right? So, in this case, Anuradha Basin versus the Union of India, they said you cannot misuse section 144 if you, I mean, if you're banning the internet indefinitely, right? जब तक हम चाहेंगे तब तक इसको हम बैंड रखेंगे दैट इज नॉट अलाउड अंडर सेक्शन 144. They're saying if you want to ban some public utility, some public service under section 144, you can do it on a temporary basis, right? As long as it is necessary to put that ban so that there is no harm caused to any other person, you can put a temporary ban. But if you are putting a ban just because you want to stop people from expressing their voice against something, you cannot use it because then it would be considered a misuse of section 144. Ab clarity आई what is section 144 and what this particular case judgment was. Everybody, क्या हुआ आज? Nobody is responding. Everybody is like, huh? Welcome to law. If you thought this was boring, you haven't seen actual law briefs then. If you think they will read like a Karan Johar movie or a Rohit Shetty thriller, you are absolutely in the wrong profession. एक्चुअल लीगल ब्रीफ्स पढ़ने के बाद तो ये आपको लगेगा अरे वाह क्या मस्त स्पीड में ये था. हैव यू रेड एक्चुअल लीगल ब्रीफ्स? इसीलिए try to go online and search. Let me see if I can come up with an actual legal brief and put it on the app. उसके बाद तो लॉ ही छोड़ देगी 90% जनता. चलो ये समझ में आया. The point is not enjoying it, the point is understanding it. Okay. Any order suspending internet issued under the suspension rules must adhere to the principles of proportionality and must not extend beyond necessary duration. And while exercising the power under section 144 of CRPC, the magistrate is duty bound to balance the rights and restrictions based on the principles of proportionality and thereafter apply the least intrusive measure. What does it mean? Two conditions.
कि अगर आप इस चीज को लाइन लगा रहे हैं तो it shouldn't exceed what is necessary.
Correct. That is proportionality. Use only that much which is required and not more.
Rights और restrictions को balance करते हैं.
Correct. And second, it says if you have multiple choices which you can do, then which one should you select? Least into सबसे कम दखल अंदाजी जो करे वो चॉइस करो. बैन करने का ये करने का आपके पास अगर दो तीन ऑप्शंस हैं, यू मस्ट सिलेक्ट द ऑप्शन विच हैज द लीस्ट intrusion, least effect on the people. Effect in the sense, least hindrance to the lives of people. Clear, Chair? Chalo.
Seats.
Riots broke out in the city of Delhi. The magistrate imposed section 144 CRPC in the city for a month. Internet shutdown was also imposed. The riots stopped within a day, but the restrictions were kept in place. Austin runs an online handicraft business. He has filed before the High Court for removal of internet shutdown after 2 weeks of the riots stopping. Decide. Right? If the riots have stopped and after 2 weeks of stopping of the riots, they still keep continuing a ban on the internet, would that be proportional? Would that be non-intrusive into the rights of the lives of the people? No. So my best option, it has to be restricted because it is not an emergency anymore. Next. दिल्ली में ही बार बार राइट्स हो रहे हैं. But which option? The situation may be the same, but the answer options are remarkably different. So riots broke out in the city. Magistrate imposed section 144 for a month. Internet shutdown. Riots stopped within a day, but restrictions were kept in place. Sarma is a trader in the city. He has filed before the High Court for removal of restriction. A तो नहीं ही है. Now B, C या D? B. D. So both B and C. Restrictions are disproportionate to the danger and should be revoked. How is the restriction disproportionate to the danger? राइट्स थे तब इंटरनेट शटडाउन किया तो डिस्प्रोपोर्शनेट कहाँ है? राइट्स खत्म हो गए, अभी भी रिस्ट्रिक्शंस हैं. सो इज दैट डिस्प्रोपोर्शनेट और समथिंग एल्स? Disproportionate means the response was never correct at any point of time. It's not disproportionate, but it is intrusive, right? When it was required, it was proportionate. So it cannot be removed on the basis of being disproportionate. But is it intrusive? Yes, it is no longer required. So my best option in this case is See, right? Everybody. 10 armed terrorists stormed the city of Mumbai. The magistrate imposed Section 144 CRPC. News channels were banned from showing visuals of the government response or of the attacks. Internet shutdown was also imposed to avoid leak of government response via public private social media profiles. Restrictions were lifted once the operation was over and all 10 terrorists were killed. Kher is a businessman. He lost 2 million in trading because the internet was shut. He filed against the state for the restriction. Decide. A says restrictions imposed were proportionate to the danger. Agreed. B. Restrictions were the least intrusive measure taken. I don't know. I don't know. Was there a lesser measure? I don't know. तो no तो नहीं कह सकता. Yes की surety नहीं है. Third option. Restrictions imposed were necessary to balance the rights of the people under threat due to terrorists. That is for sure true. Then A and C तो 100% sure है. And B is not clearly against. So my best option in this case definitely becomes B. D. All of the above. Okay. The central government called for overnight evacuation of the state of Jammu and Kashmir in August. The state was converted from a full state to two union territories. An internet shutdown has been going on in the state for 9 months now in anticipation of a backlash by the people. A group of businessmen filed for restrictions to be lifted as the internet is necessary for online tourism bookings. And decide. A. First one. Restrictions are violative of their rights as they're being used to curb the democratic speech of the people. Okay.
They cannot go online and speak about it.
Why was the internet shutdown put in place?
It was not.
Backlash by the people का इंटरनेट के साथ क्या लेना है? What do you mean by backlash?
वो इसलिए legal नहीं है.
What will people do?
Protest वहाँ पे.
Through internet, the only protest you are going to do is tweet about it, post about it, technically express yourself, right? Other than that, anything? Let's see. B says restrictions is valid as the security of people will be in danger, which is imminent. कौन सा imminent danger है जिसको 9 महीने से आप सॉल्व नहीं कर पाए हो? C. Restrictions are valid as Pakistani terrorists will use it to bring. I'm not even going to comment about that option. The restrictions are valid as the territory is a union territory and the central government has authority to. खालाजी का बाड़ा है क्या? कुछ भी कर सकते हो तुम लोग? नहीं. The only option best तो होता है जब एक से ज्यादा अच्छा हो. The only option which is valid is A. Right? Restrictions are definitely violative of rights because backlash of people fear कर रहे हो. That means you don't want people to say anything against you. चलो, ये तो easy था, पक्का. Okay. The world is suffering from an influenza pandemic. The state government imposes the ban on the internet in the entire state for a week to spread the virus.
To spread the virus.
Decide the validity of the step in light of principles mentioned above.
फोन में से पहला
इसीलिए मैं ऑप्शंस भी देख रहा हूँ. World is suffering from influenza pandemic. State government imposes ban on the internet in the entire state for a week to spread the virus.
Stop the spread of
Let's assume it's a typo and to stop the spread. चलो वो कर ही देते हैं लाइफ में. Stop the spread of virus.
B.
B.
B. Information organization paradigm.
So information lockdown is valid to avoid spread of rumors. Information lockdown is invalid as internet shutdown has no effect on the spread of virus. Information lockdown is valid to avoid spread of bad press for the government. ये तो freedom of speech. And information lockdown is invalid. Internet was distracting health. I would have somewhat agreed with this if it was that it is internet was distracting students from studying online. If the government puts a ban on the internet for students, I would be the first person to vote for that government.
Delhi or Mumbai actually did it. I think Mumbai did it.
What?
China and Mumbai has banned like technological like mobile phones, tablets from school. So like students cannot get it.
School में.
पहले से
Vote for whoever brought that law.
अरे सब स्कूल में था.
Huh? Mobiles are allowed.
रिवर साइड में था.
भगवान बचाए स्कूल टीचर्स को.
मुंबई ने बैन कर दिया.
What requirement do we have for a mobile phone in a school?
No, like for Riverside, they have AIs, but AIs they have laptops.
सर हमारे अलाउड नहीं है बट आई टेक इट एंड सबमिट इन द एडमिन क्योंकि जब मेरे को बस अपने घर से दूर छोड़ दिए 4
हाँ.
किलोमीटर से मेरे को वो बुक करनी पड़ती है.
Okay.
दैट्स व्हाई आई
But
टेक इट एंड सबमिट
you basically submit it to the admin, right? You don't sit in the class and keep tapping. Obvious नहीं है क्योंकि यहाँ पे 90% जनता कर रही है. ये फर्स्ट बेंच पे बैठ के कर रही थी तो. Anyway, the world is suffering. क्या होना चाहिए इसका आंसर? The only valid option is that it has nothing to do with the spread of the virus. And obviously, the previous thing that for spreading the virus, they wanted it. Nah. Okay. We don't have enough time to read and to the next set. So we'll take a break here. We'll stop here. Right? Don't always expect your passages and questions to be very interesting where we will play detective. Sometimes such boring questions also come in the examination. You have to be prepared for it. But today what we understood is sometimes in the paper, because you have access to both the questions and the passage together, read the passage, read the questions first, so that in many cases you can directly answer them without referring to the passage. Or maybe after reading the questions, you will realize, okay, do I actually? So you can just skim through the passage to understand whether there is any relevant information there or not. Right? Chalo. We'll quickly take the attendance here and then tata bye bye. See you. या ना पता है उसके पीछे राही राही ना सी मुश्किल से नाम याद रह जाता है कभी कभी यजदान दिस हाउ मेनी आई रिमेंबर जोशी जोशी 3-4 हैं बट फीमेल वाली जोशी ओके हाँ probably V he is today V Shaw Anshdeep Ammar Adi Arma પતી ગયું મળીએ પછી ચલો
with me and my friends without and submitting it to
When I cannot give you before the test, I can give you after the test has started. Or tomorrow. नहीं but tomorrow फिर submit मेरे को ओवन check करने में time लगेगा.
I'll complete the QR.
Before the question paper is given to the people, I cannot give out the question paper. Anytime after the test starts, I can give the question paper.
Not the question paper, OMR. You, if possible, can you a question paper like aptitude answer?
3 बजे के बाद हाँ
हाँ हाँ
तो मुझे लेकिन कल क्लास में सुबह सबमिट करना पड़ेगा.
हाँ पर I reach home by 7:30 and give the paper at 8.
But 2 hours.
हाँ
नहीं, ideally 1 hour.